all persons having business before the Honorable Chief Judge and Associate Judges now presiding over the District of Columbia Court of Appeals draw near and give your attention. God save this United States and its honorable court. This honorable court is now in session. Please come to order.
All right, good morning. Welcome to the virtual oral arguments for the District of Columbia Court of Appeals, which we've been conducting on this virtual platform in light of the ongoing COVID-19 related health concerns. I'm joined this morning by Associate Judge Deal and Senior Judge Stedman. We have 3 cases to be argued today, the first of which is Brian KHARI GILLIAM versus United States. Are the parties ready to proceed?
Yeah, sure.
All right, good morning.
Good morning. Mindy Dan, I'm sorry.
We apologize for starting a little later this morning. Thank you for your patience. Ms. Daniels?
Yes, good morning. Mindy Daniels for appellant Gilliam, and I'll reserve 3 minutes for rebuttal, please.
All right.
Okay. We argue on appeal with respect to the IPA claim that the files and records did not conclusively show that he was entitled to no relief and he should have been granted a hearing, and that the court, in drawing its conclusions in its written order, did not address certain factors, and other factors that it addressed, there were some inaccuracies or mistakes. So a hearing is not required, only if the claim is vague or conclusory, that it's palpably incredible, or even if true would merit no relief. And the court focused on, as well as the government, focused on those last 2 factors. And we disagree that it was palpably incredible, and with the last factor as well.
Ms. Daniels, one of your points about the trial court's denial and your concerns with that was you stated that you didn't feel he correctly compared it to, I think the facts in the Bell case primarily is what you rely on for distinguishing the result here. That in Bell, I think the witness was not clear about which part of the testimony was being recanted, and therefore it was harder there to distinguish whether or not it was incredible or credible to support innocence. And here, the recanting witness, the co-defendant, specifically focused on that fact about Mr. Gilliam not having a weapon, which contradicted his trial testimony and the trial testimony of at least 2 other witnesses. So Judge Gardner seemed to be saying 2 things. One, Mr. English's testimony in itself was incredible because it so starkly contradicted some of the facts at trial. And then he also focused on the other evidence at trial that clearly recanted his new testimony and clearly contradicted his new testimony. And we have a lot of case law that seems to say that there's a high bar to overcoming credibility when you're talking about recanted testimony. And even more so when you have the same trial judge who's reviewing the IPA motion. So I just wanted to get a clearer sense of why you think some of his rulings with regard to credibility and the other evidence at trial, that even if Mr. English had been not so incredible, according to Judge Gardner, still contradicts and prevented him from concluding that Mr. Gilliam was innocent.
Okay. With respect to what the court
that was
said
long.
about,
I'm sorry.
I got it though.
Thank you.
Okay, so with respect to the Bell case, just addressing that briefly, in Bell, the recanting witness recanted his entire trial testimony, And the court also found that his trial testimony was overwhelmingly corroborated by other witnesses. And in this case, actually, and Judge Gardner said that his affidavit, English's affidavit, was consistent with most of his trial testimony. What he recanted, what he said at trial was that on his way back from shooting Beckham, he saw Gilliam, and that they both then ran to the car and were looking backward with guns to see if actually Beckham was going to chase them somehow, in Mr. English's mind, and that they were both pointing guns in that direction. And then that's what he recanted. He said that he never saw him with a gun, and that he said it because he thought it would help his own self-defense case. He said he didn't want to look like a bad guy with two guns, because he said he had both guns. There was evidence there was a 45 semi-automatic and also a lot less, but 9mm shells as well. And he also said he thought it would help his self-defense if he put a gun in someone else's hand, so that he was not alone in his fear of Beckham. And actually,
how much sense does that make? Isn't the self-defense claim predicated on Beckham was shooting at us? We were shot at first. If that's true, who cares if somebody else has a gun? Why would it make sense at all to say the second person having a gun would make my self-defense more reasonable? Anybody's going to be worried if they're being shot at. The question was that factual account true? And I just don't see why somebody would fabricate and another person had a gun, and I don't see how that lends any credence to a self-defense claim.
Well, the history to this too was that English wanted, and he actually did a trial to put on a showing of how dangerous Beckham was, and that people in the community knew it. And what occurred, there was a big discussion about it, but the government insisted, and the court ultimately said that, well, if you're going to put on that kind of evidence, you have to testify first that it was self-defense. So I'm not so sure that English even planned on testifying and was just hoping to get this bad stuff about Beckham out there. And so, and then he's like, oh, I'm going to have to testify, and I'm going to have to show that I was really afraid of this guy because, he didn't have a completely perfect self-defense. He said that he was shot at while he was in the car, and then he shot at him in the car. Then he got out of the car, shot at the car again. And then when Beckham ran, he ran after him. So in English's mind, it was very incumbent upon the jury to believe that, regardless of whatever his self-defense claim was going to be, that he was really, really, really afraid of this guy, and this guy was to be feared, and that was, a reason why he carried a gun. Or maybe he didn't plan on putting a gun in Gilliam's hand at first, and was going to say he had both guns, but then thought, well, that would make me look bad.
Well, but I guess ultimately, Judge Gardner's point, as I understand it, was that there really wasn't, or maybe you could point me to if you think there wasn't any other evidence at trial that contradicted the two other witnesses, Ms. Morrison and Tammy Morrison and Ms. Davis, that the appellant had a gun. Or am I missing some other evidence at trial showing that Mr. Gilliam was not armed and did not fire any gun?
Yes, I'd like to address what Judge Gardner did rely on, and it was those two witnesses, Ms.
Right.
Morrison.
But was there other evidence at trial that contradicted any of the testimony that appellant had a gun? Because all the testimony at trial seems to have been that there were two people with each having a gun and both shooting.
Well, you know, as Judge Gardner said at one point, no witness pointed to any defendant and said, this is the person who had a gun, this is the person who was shooting. And, you know, so, you know, it was always going to be a question. I mean, the government had its theory, but it was always going to be a question of that if there were two people with a gun and there were three guys, which two people actually had that gun. And so, and who did what? So it was a very long trial. Many of the witnesses were impeached on various factors, but I would like to concentrate on Ms. Morrison and Tia Davis for the moment, because that's who Judge Gardner focused on in his ruling. So Ms. Morrison's testimony was that the night, well, her testimony was basically rejected by the jury, and rightly so. What happened with her was that she was the basis for the conspiracy charge, as well as the premeditated murder, because she said in her grand jury, at least, that they discussed getting Beckham the night before. And then she said Gilliam and English came back for guns in the morning. At trial, however, she said that it was her suggestion that they get him. So she really backed off from that at trial. They also were able to impeach her that she was using PCP, she was bipolar, she was not taking her medication at the time. But we do know that the jury acquitted them of the conspiracy charges and the first degree premeditated murder. So if they credited her testimony about, well, her testimony even in general, that that the verdict would have come out differently. So I think that reliance on Ms. Morrison is not very weighty, and it's very weak, because we already know that the jury didn't credit her testimony. As far as
we don't know that they didn't credit it. We know that they didn't find a conspiracy, but that doesn't mean that they didn't find that other parts of her testimony about the appellant and his co-defendant both having guns was incredible or discredited.
Well, also English impeached her testimony, and he said that they never went there to get guns, and that whatever she was saying was untrue. So there was that as well. I'm just saying that it's not strong testimony. And we do know that the jury did reject much of it. I mean, we can't, really know exactly what they relied on and didn't. But as far as Tia Davis, who Judge Gardner refers to as Ms. Austin, and that was just, misnaming it, I assume.
Let me ask you this. To even get to a new trial, you have to show by a preponderance of the evidence that he was innocent. Here we have two witnesses that say that he had a gun. The third witness, the recanting witness, previously said that he had a gun, but now recants it. How can we say that that he's shown by a preponderance of the evidence that he's innocent? That's a pretty tough thing to get your head around.
Well, like I say, there was a lot of confusion at trial as to who did what and what part each person played. For instance, Dennis Austin testified that it was English who was shooting at the car. Tia Davis testified, not in coherence with the government's theory, that it was Mr. Gilliam that actually killed Beckham.
Don't they both say there were two shooters, regardless of where they put each one of them?
Well, I think that Austin testified that there were two men with guns, but it was the man in the black shirt shooting at him in the car. He didn't see the man in the striped shirt shooting, and that was, I believe that was his testimony at trial. And Tia Davis testified that it was the man in the striped shirt that killed Beckham. So there was a lot
I guess my question is more simple, which is, don't they both say that there were two people with guns? Consistent with Ronald English's trial testimony, inconsistent with his recantation.
Well, I believe that they said that there were two people, but they never said which two people. There were three men.
Right, but what was Mr. English's recantation testimony? That somebody else had the second gun, or I had them both?
He said he had them. He said that he had them both. And I guess the point I want to make is that things didn't happen in slow motion. They happened very quickly, and the witnesses were impeached in many respects. In fact, Tia Davis, when she made her 911 call that was admitted into evidence, she said that her car was hijacked and stolen. She didn't even report a shooting or how many gunmen or any of it. And, and also, this is supposedly, coming out of a car with tinted windows. And so, it wouldn't be easy to see who was who or what was what. That was another factor. But I want to address Judge Stedman's question as well. I think that, I mean, I would say that, after if there was a hearing in this matter, I think that I would have to be up here claiming that Judge Gardner's findings were clearly erroneous, and then we would get to, was there a preponderance of the evidence, and or clear and convincing evidence. So what we're arguing on appeal is that he was entitled to a hearing because the affidavit in and of itself was not palpably incredible, as he found. And so, Mr. Gilliam's defense the whole time, as I see it and I read it, was that he was innocent, and if he did have a gun, that it was in self-defense. So he had an alternative theory. And I lay out in the briefings why I say that. The only thing I want to add is that on the transcript, the government just got the transcripts on Monday and shared them with me. So thousands of pages to go through rather quickly. But on December 10th, on page 22, the court said there was no witness who pointed to a defendant and said he's the one who shot. The only issue is who did it. English said what he did. The other defense is innocent presence. So, again, things happen very quickly. Even if the court, I mean, I don't expect the court to read thousands of pages of transcript, but even if it just read the closing arguments that lay out the testimony, the impeachments, all the impeachment, that there's nothing that clear in this case, or at least not as clear as the government wants to make it.
All right, Ms. Daniels, I'm gonna, if it's okay, I know you reserved some time for rebuttal. Our questions may have taken you a little bit over your time, but we'll give you additional time for rebuttal so we can hear from the government. Okay, thank you. Mr. McGovern.
Thank you, Your Honor, and good morning. May it please the court, Michael McGovern on behalf of the United States appellee in this matter. The trial court did not abuse its discretion when it denied appellant's motion to vacate his conviction or for a new trial. Rather, the trial court...
we have to say that the trial court order perhaps could have been clearer. There were some things that maybe were a little confusing in the manner that the order was written. One of the concerns was whether the trial court was clear that he had the discretion not to deny the hearing. I wondered if you could maybe briefly address that, whether there's a sufficient basis for us to be able to have assurances that the trial court properly exercised his discretion and didn't feel that he was compelled to deny the motion.
Yes, Your Honor. The government's position is that the order does in fact contain enough assurances that this court can be sure that Judge Garner was considering the credibility of the affidavit overall and didn't feel compelled simply because it was a recantation to deny the credibility. He cited to the Bell case and he repeatedly stated that he had the ability to determine the credibility of the affidavit without a hearing. And he relied on that in order not to have a hearing. And then he went through the reasons that he discredited the affidavit. And those reasons did not rely solely on the fact that it was a recantation. Although he first said that recantations are viewed with great or utmost suspicion, that was consistent with this court's case law and set the starting point for where he considered his evaluation of the credibility to be. He then noted that it was necessary, because there was a recantation, to take into account that this is an individual who has on at least one occasion lied to the court under oath, which is a valid consideration for credibility. But then he went on to state that none of the facts contained in his recantation, looking at his recantation as simply the fact that GILLIAM did not have a gun.
But so you would, I think, just to kind of pick up on the Chief's question, you would agree that the Judge Gardner, seemed to say something along the lines of, when we're dealing with a recantation, I can't trust it because it means he lied under oath then, so now I can't trust him. I can't trust what he's saying now. He seemed to say something that sounded like that, right?
Yes, Your Honor, I believe that he believed that it was appropriate consideration in the determination of credibility, but he didn't let that be the sole.
Oh, sure. I mean, I take your point. There was, I guess what I'm saying is, he articulated a rationale, which would seem to say, anytime there's a recantation, it's no good because they previously lied, and so I couldn't trust the recantation either. Now, I'm not saying that's the only thing he said, but he said a thing that was probably not right. Do you agree with that?
I don't, Your Honor. I believe that what he did was he cited to multiple precedents where this court has said the very thing that Judge Gardner said, which was, we view the recantations with the utmost suspicion. That we don't start at a neutral place with credibility where there's a recantation. We view them with the utmost skepticism. That calls into question at the beginning of the inquiry the credibility of the person who is doing this. And had he stopped there and said, simply because he recanted, I can't believe it, that would not look at, that's not what was done. Instead, he went on to say, but I need to see whether or not there is anything that corroborates what he is saying, which would rehabilitate in some sense his credibility, or whether or not all of the other trial testimony was consistent with his original testimony, which is what Judge Garner then did.
I agree with a lot of what you say, but I guess I don't understand why you're fighting me on the first step. I agree he said more. He said things that suggest he understands that recantation alone doesn't mean that the person can't be trusted. But he also said, and here I'm quoting from pages 6 and 7 of the order, due to Mr. English's recantation, he has perjured himself on the stand. And now the next part I agree with, that causes the court to question his credibility. Like that's certainly consistent with our case law. It's a reason to doubt. But he then goes on to say, we have no choice but to find it not credible because he admits to perjuring himself on the stand. That I guess I'm wondering why you want to defend that. I mean, yes, people can make mistakes when they talk. The order said other things that suggested a correct understanding of how this works. But that, I think, is not unquestionably a bad way of thinking about it.
So, Your Honor, I think if that sentence were viewed in isolation, if his analysis ended with that sentence, I understand Your Honor's concern that it indicates that he is using this as a sole criterion and that he does not have any discretion beyond that. But what I'll note is that is the first sentence of an entire paragraph, which ends with, further, Mr. English does not provide any other evidence to enforce other than simply saying he took no part. So he's saying that he's not providing any corroborating evidence, anything to support this view of the evidence. So when read in the context of the entire order, there's no reason for this court to believe that Judge Gardner was denying this claim simply because there was a recantation. Judge Gardner was clear that he was denying it because there was no corroboration of the new statement, and that all of the evidence in the trial that he had seen corroborated English's initial testimony that Gilliam did have a gun. And so although that sentence standing alone may give the court pause for concern, when reading the entirety of the order and when viewed in context, I believe what's clear is that Judge Gardner was making a fulsome assessment of the credibility, beginning with what this court has said, which is that the credibility determination is weighted in favor at the beginning skeptically, that we view the credibility of recanters skeptically because they have at least once, either in their recantation or in their trial testimony, perjured themselves, been willing to testify to untrue facts.
Let me ask you this. The main argument on appeal is simply, he should have given me a hearing. So the first thing we have to face is whether or not the criteria for denying a hearing have been met. Now, it seems to me there's two possibilities. One is the one about the testimony is inherently incredible, or some words like that. And the other one is, even if true, he's not entitled to any relief. And I'm wondering which one you think, or maybe both, apply here, because inherently incredible, I'm not quite sure that he really quite says that, although the other one is, if true. And I'm wondering, what does it mean, if true? Does that mean what he says is true? He did not have a gun. Or does it mean simply that even if you accept that he is testifying truthfully, still it would not be enough to provide relief for the reason I previously mentioned, which is that he hasn't shown by a preponderance of the evidence that he's innocent. Which of the two, or both?
Your Honor, I believe both. as an initial matter with respect to whether something is probably incredible, this court has previously found that no hearing is necessary to evaluate the credibility of a recantation by a trial judge who has seen the entire trial. And so, which was the case here. Judge Gardner had been the original trial judge, had seen English's prior testimony and all of the testimony in the trial. Therefore, he was permitted to make the credibility finding, and by finding the recantation incredible, there was then the claims that he didn't have a gun were themselves, without any credible basis, palpably incredible. So we believe that the first does apply. But to Your Honor's second point, if true, in this case would mean if English would have truthfully testified, this is what he saw, he did not see him with a gun, he did not know he had a gun, would that merit relief? And as Your Honor indicated, given the large amount of evidence in the trial that showed that Gilliam did in fact have a gun, even if English had been permitted to recant, even if he had been he had stated that Gilliam didn't have a gun, that in and of itself was not significant enough to show by a preponderance of the evidence that Gilliam was not guilty, because there was such substantial other evidence that placed a gun in his hand.
Mr. McGovern, let me go back to your explanation on the prong about credibility. We do have cases like Bell and Kearney, which say that
Chief, you're breaking up, and I don't think we've been able to hear.
The trial, who's now reviewing the IPA, hear me now?
Yes, that you're back, but I think we missed the last 30 seconds.
We have cases like Bell and Kearney have given a little more of a path, if you will, to denying a hearing where the trial judge is also reviewing the IPA motion, because we say that the trial judge had firsthand knowledge of the trial testimony and the credibility. And I guess my question is, how far do we extend that? Is that just weeks, days? Here we're decades after the actual trial. We're to presume that the memories and credibility findings are still so fresh that no hearing is needed. That may be more of a rhetorical question, but here a lot of time has passed. And while we have the original trial judge, was a hearing needed to sort of refresh everyone on the testimony and revisit the credibility assessments of the witnesses?
Your Honor, no, we don't believe a hearing was necessary here. That there's never been a time frame placed on this, and I haven't looked at all of the cases, but the cases that Bell relies on and Kearney is a long-standing in both federal court law and in this court's jurisdiction, that where there is a recantation in support of looking for a new trial, that a judge who heard the trial testimony would be in a place to judge the credibility of that without a hearing. That's been very long-standing, and I would venture to say recantations in the past must have happened years later as well. And so I'm not sure that there has ever been a time limit placed on that. I have not seen one, and we don't have any reason to believe so, because once the briefing is done, the trial judge at that point, his memory may be refreshed. He may say, this was a particularly gruesome crime, or this was a particularly interesting crime that may refresh their recollection in the same way. And so, no, we don't believe that there's any time limitation that we've placed on that.
Can I just ask you a question about your legal point that this does not even qualify as new evidence? And I suppose let me ask about that in a slightly alternative scenario. Let's say, in addition to the recantation, Mr. Hargraves says, I was the one, in fact, who had the other gun, and Mr. English agrees, yes, it was Mr. Hargraves all along. Would that qualify as new evidence under the IPA?
No, Your Honor, we don't believe that it would.
Because Mr. Gilliam could have said that at trial, even though he has a confession from somebody else that comes up later. You don't think that's new evidence? I guess I just want to hear the explanation for that.
So, Your Honor, I believe two things. First, it wouldn't be new evidence because, as an initial matter, there was, I think it depends on a number of questions. One is whether or not, under this new scenario, Hargraves was subpoenaed to testify and invoked his Fifth Amendment, and also a question as to whether or not Gilliam himself took the stand and testified to the facts that he's now claiming are the new evidence. Because the new there's no new information for Gilliam at that point. The defendant was aware of, at the time of trial, under your scenario where Hargraves had the gun. He would have been aware that Hargraves had the gun.
Yeah, but it's a really, but we're talking about new evidence. We're not talking about, it's a really funny position to me to think if one person knows they're innocent and says, I wasn't there, I was somewhere else, and they get convicted, and then they find 100 people after the fact that say he wasn't there, he was somewhere else, and here's the guy, you're going to tell me, or forget about here's the guy, just he wasn't there, he was somewhere else. You're going to tell me that's not new evidence. Sure sounds like new evidence, but you're going to tell me it's not new evidence because it was evidence supporting a thing he already knew at the time of trial. But he couldn't prove it. And that's what makes it such a, to me, untenable position. And I just don't get it.
I apologize, Your Honor, but your Honor's hypothetical supposes that the individual did say, I wasn't there. That they not only advanced the alibi defense, but they testified to it, and that they later came upon some information. Now, if by diligence they couldn't have discovered that information or wouldn't have had it, then the question would be under the authorities whether or not that was simply cumulative or not. And what we could argue about whether or not the fact that there was no prior corroboration, but now is corroboration, is or is not cumulative. I think that's a different question. But
your position, just so I understand it, is that he wasn't diligent enough about getting Mr. English to say the truth.
Two positions, Your Honor, both that he didn't cross-examine at all English, who was on the stand and was therefore available to him and to testify.
But no indication he would have said anything other than what he said on direct, though, right?
Well, but Your Honor, I'll point you to Bachnight, where this court found that the diligence prong required someone to subpoena someone who they believed and had reason to believe would have asserted their Fifth Amendment privilege. So there's very little daylight between what happened in that case and requiring cross-examination in this case. But above and beyond that, Gilliam himself could have taken the stand and testified that either that he didn't have a gun or that he saw English with two guns, but he also chose not to do that. And so in both of those ways, I'll also note with respect to diligence, he didn't argue in any way, shape, or form that he didn't have a gun. That simply wasn't the defense he presented at trial. At trial, the defense he presented was self-defense. And I will encourage you to read, as Ms. Daniels did, the closing arguments of his defense attorney, which repeatedly states that he was protecting himself, making the affirmative point that he was shooting the gun. And so in fact, he did far more than not say that he didn't have the gun. He admitted in closing that he did have the gun and pursued instead the self-defense. And so our point is that simply doesn't indicate that he was diligent at trying to put before the court or the jury the fact of that he didn't have the gun, which is not new to him at this point. He would have known at that time.
All right.
If the court has no further questions, we'd ask that you affirm.
All right. Thank you, Mr. McGovern. Ms. Daniels, we'll give you a couple minutes for rebuttal.
Yes, thank you. I would like to quickly say some things in response. First of all, the fact that he didn't cross-examine English. I went to a course recently on cross-examination by the Public Defender Service, by the training director there. And the one thing they wanted all of us to walk away with was, if you're not going to get anything on cross, don't cross just to cross, just to have the witness repeat what they said that has already hurt you. So the fact that he didn't cross, I don't think is so dispositive. And if he had taken the stand, his testimony really would have just been impeaching of English. He was still stuck with Mr. English's testimony. As far as new evidence, Kasten versus the United States that we cite says that the new evidence provision of the IPA is broader and more inclusive than the judicial test for newly discovered evidence. It specifically provides for evidence that was known at the time of trial but could not be produced. And he couldn't force English to, tell the truth if English was going to say what he was going to say. And I also want to address what Judge Stedman said at the beginning, which is, what we're up here saying is, give me a hearing. And what we're up here saying is that Judge Gardner's order was not, for the reasons he gave, does not back up not granting a hearing. And first of all, is that saying the no choice part, which Judge Deal has already gone over, and I won't repeat it. I think the court, understands what happened there. The second was, and Mr. McGovern addressed this at the very end, that he said, please, look at these closing arguments. Well, we addressed that too, and we specifically state that in the closing argument, in the opening argument, actually, the defense was not self-defense. He just said he did nothing wrong. Gilliam did nothing wrong, and you're going to acquit him. Then in closing argument, he said, well, you say, what about the gun? If you believe he had it. And then he goes on the assumption, if you believe he had it, then it's a theory of self-defense. So it really was an alternate theory. It wasn't one theory. And like I say, even at 1210, page 22, Judge Gardner said, we know one is self-defense and the other defense is innocent presence. So he probably forgot that small line in a month-long trial. But, as well as the instruction in the case. The other thing that's very important here is that Kasten says, when an IPA claim is before the court, the trial court cannot discredit the inconsistency without taking into account the explanation given. And Judge Gardner did not take that into account. So we're asking for a remand on that basis, as well as that the court said Mr. English had nothing to lose, but he did not address at all the statement in his affidavit that he understood that he could be charged with perjury. He relied on Ms. Morrison and Tia Davis, and they were very substantially impeached in many respects. And it's also important to remember that even though all three defendants were charged with everything, that the jury only found Hargraves guilty of fleeing from a police officer, even though he drove the car there. He supposedly was the driver who cut off the car. He waited for them. He drove the car away 100 miles an hour for 40 minutes and didn't stop until they crashed. So in this particular case, the jury gave Hargraves a pass. They were willing to let English take responsibility. And so I think that in the context of this trial, it becomes pretty clear that they relied on English's testimony, including the fact that he said that Gilliam had a gun. And if he had said that he didn't have a gun, the jury may have given Gilliam a pass as well. since the evidence was so clear, including his own admission of who actually did the killing. You know, and in addition, I just want to note that, to be honest, if I was the attorney on the direct appeal of this, I would have been claiming that there wasn't really any evidence of aiding and abetting the murder. That even if you know, Gilliam had a gun, you know, he's not the one that chased down Beckham. He's not the one that killed Beckham. You know, but English's testimony tied him to that. And I think that's an important thing to understand here, is that it was English's testimony that put him running away with him from the killing of English, whereas any other testimony in the case, even if you believe he had a gun, only put him at the ADW and AWIC charges and not the voluntary manslaughter.
All right. Thank you, Ms. Daniels. And thank you, Mr. McGovern. Appreciate both of your briefs and arguments today. And we'll take the matter under advisement.
Thank you for your time.
All right, and you're both free to exit our virtual courtroom at this time. All right, good morning. Our second case today is BDO USA LP et al. Versus Eric JIA-SOBOTA et al. Parties, if you could identify yourselves for the record and indicate how you would like to proceed.
Good morning, Your Honor. My name is Michael Kimberly. I represent the appellants in this case. When the time comes, Your Honor, I'd like to reserve 4 minutes of time for rebuttal.
Good morning, Your Honor. Brian Walsh for the appellees, Eric JIA-SOBOTA and Everglade, and I'll be arguing on behalf of both appellees today.
All right, thank you.
Good morning, Your Honor. Tiffany Joseph Goodson for the appellee, Eric JIA-SOBOTA, and I have yielded my time to Mr. Walsh.
All right, thank you. All right, Mr. Kimberly, are you ready to proceed?
I am, Your Honor. Thank you. As I mentioned, I'd like to reserve 4 minutes of time. Your Honors, this case presents two broad issues. The first is whether or not there was a waiver of the arbitration right in this case. And the second is whether the arbitration clause in the parties' agreement is enforceable. And if I may, I'd like to start with waiver because that's the basis for the Superior Court's decision. I'll lay out the legal framework and then talk a bit about the facts. And then once we exhaust those issues, I'd like to move on to the enforceability question. So as a starting point, the substantive law applicable here is a mix of federal and state law. As a starting point, the Arbitration Act requires courts to rigorously enforce arbitration agreements according to their terms. And that includes terms that specify who the parties choose to arbitrate their disputes and what sorts of arbitration rules will be applied. Waiver against the backdrop of both New York and federal policy strongly favoring and encouraging arbitration requires a very strong showing of behavior on the part of the party who is attempting to pursue arbitration.
You know, Mr. Kimberly, I'm curious why you reference New York and federal law, but not our RUAA, or I forgot what the R stands for, Revised Arbitration Act, which is our District of Columbia statute, as well as some of our District of Columbia cases. I was curious. I didn't see reference to that in any of the briefing.
Your Honor, I think that's straightforwardly because section 16.9 of the agreement specifies that New York law applies to the construction and applicability of the arbitration agreement here. That appears at page 96A of the appendix. And if it's helpful, I can briefly read it. It says that the arbitration agreement, that the validity, construction, administration, and effect of the provisions of section 14.7, which is the arbitration clause, shall be governed by and construed in accordance with the laws of the state of New York. And as we cite throughout our briefs before this court and the court below, courts have routinely applied choice of law provisions like this to questions of both waiver of arbitrability and the enforceability of arbitration clause.
Where did you make? Sorry.
I apologize. Just one quick follow-up. Are there any key differences between the New York arbitration statute and our District of Columbia statute that we should be aware of just by point of information?
There is, I think, one difference that I think warrants a little bit of attention, but I would say before I get to that, our position certainly is that regardless whether New York law or DC law applies, there's no waiver here and the provision is enforceable. And I'm happy to talk in particular about the court's recent decision in TRG, which we think is distinguishable in every relevant respect from the facts here. I think the one potentially relevant distinction is that New York law specifies that decisions to move to dismiss on the merits do not waive arbitration. Here, we think the motion to dismiss the non-arbitrable claims doesn't give rise to waiver regardless, but as a fallback argument, certainly even if it did under settled New York law, that wouldn't amount to a waiver.
When it comes to examining a waiver under either DC or New York law, can you point me to where in the trial court you argued that New York law applies to that question and not DC law?
Yes, Your Honor, we cited this in our reply brief. And if I may, I'll just scroll to that portion of the brief. It's right at the outset. We explained in our opposition to Mr. Sobota's motion to stay arbitration at pages 6 to 7 in note 1 that quote, and I'm quoting from a brief now, the partnership agreement's arbitration clause is governed by New York law. In addition, and that was citing the choice of law provision I just mentioned.
It doesn't sound like New York law governs whether or not it's been waived though. So what's?
No, I'm sorry, Your Honor. So the arbitration, the choice of law provision itself states that the question of the validity, construction, administration, and effect are all to be construed in accordance with the law of the state of New York.
Do you think waiver is a question of administration?
That is our position, Your Honor. And I would note also that in our reply brief, we cite a number of cases at footnote 1 on page 4, where courts have construed choice of law provisions to apply specifically to the question of waiver of arbitration. So I don't think there's anything novel about our position on this point. But again, to the Chief Judge's point or question, I would say first and foremost that the outcome here is going to be the same either way. And that's so for a range of reasons. First, regardless whether it's DC law or New York law, waiver requires conduct that is completely inconsistent with the right to arbitrate. And that includes, among other things, the imposition of unreasonable delay before the question of arbitration is even raised. And in prior cases, courts have found that delays of many, many months or even years are what constitute unreasonable delay.
Well, so the prior cases are almost exclusively defendants. I think you cite to one where a wrongful eviction claim where it was a plaintiff who brought it and then it was brought as a counterclaim in a contract suit, which strikes me as quite different than this case. So it's unusual that you're a plaintiff who initiated the litigation, who propelled the litigation, and then says, but we want to arbitrate. But what you say to that is, well, all along we were saying we wanted to arbitrate. So I want to press on that. What took you so long to constitute an arbitration panel?
First, and I can come back to this after addressing your question directly, Your Honor, there are, of course, counterclaims here. which we have moved to compel. So in that posture, we are, of course, defendants pursuing an arbitration right.
And as to those, yes.
As to the question of what took us so long, perhaps Your Honor is referring to the incorrect and I'd suggest very misleading implication in the answering brief that we waited until October to constitute an arbitration panel. That is in fact not the case. First, we filed on June 5th, just 10 days after the filing of the complaint in this case, a demand for arbitration. The complaint, of course, which preceded that demand by 10 days was itself captioned as a complaint only for preliminary injunctive relief to preserve the status quo during the time that it took to set up the arbitration and while the arbitration proceeded. That maneuver by itself, I would note also, is consistent with the plain terms of the arbitration agreement, which specifies expressly, and this is at page 88A of the appendix, that the parties, quote, may seek provisional remedies from a court.
I want to know what you did to constitute the arbitration panel.
Certainly. So the first step on this front, Your Honor, was on June 29th, and I would point the court to Exhibit A to Mr. Sobota's November 2nd, 2020 opposed request for an order to show cause. And that is the first point at which we began naming proposed panelists.
That's after the TRO has been denied, correct?
That's correct, Your Honor. Having said that, I mean, I can walk through the various steps of how the request for an injunction to preserve the status quo in parallel with the starting up of the arbitration were all moving in very quick succession. So let me just first pause to say the arbitration agreement envisions a process where the parties name proposed panelists and they then negotiate who actually will constitute the panel. There can be objections. The parties work through all alternates. The June 29th submission tipped off that process. Mr. Sobota then refused to participate in the process.
I guess my question is, why didn't you tip off the process, which is entirely within your abilities, prior to getting a adverse ruling on the TRO? I mean, the gist of what the trial court said here is, yeah, you can bring a suit for provisional remedies. But here, what you did was you exploited the discovery process to try to get a leg up in arbitration, despite having no real interest in provisional remedies, because you delayed those yourself. You had asked for extensions of time to get the provisional remedies to September so you could get more discovery. That's the gist of what the trial court says. And I guess I just want to know what's wrong, what's incorrect about that. It sure looks like that.
Yeah, there are a number of things that respectfully, Your Honor, are not accurate in that description. First of all, I don't think that's what the Superior Court based its decision on. It based its decision on three elements. First, that we moved to dismiss two non-arbitrable claims, which obviously cannot result in waiver of arbitration.
Yeah, I mean, forget about that. I'm not concerned about that.
And then it was that we moved to compel arbitration of the counterclaims until after denial of the request for a TRO. But the TRO was directed entirely at BDO's own claims. The only claims that were before the court on our request for a temporary restraining order were those that comprised our request for temporary injunctive relief to maintain the status quo. It was after the filing, first, after the filing of the complaint in aid of arbitration. Second, after the filing of a demand for arbitration. Third, after Mr. Sobota, not after, but shortly before the TRO hearing, that Mr. Sobota filed counterclaims. We then moved to compel those counterclaims to arbitration a mere 18 days later. 18 days.
Counsel, I still haven't heard an answer to my question other than you don't think that's the basis for the trial court's ruling. But when I look at the trial court's ruling, the first thing the trial judge says is that it was the participating in extensive discovery as well as the delay in the request to compel arbitration. So let's just focus on the first one for a second. If the trial court says, this looks to me like what's happening is in arbitration, there is no right to discovery. I think that's correct. And it looks to me, given all things considered, that what BDO is doing is trying to exploit the discovery process to get a leg up in arbitration with no actual interest in a provisional remedy. And that is inconsistent with their arbitration rights. If that's the trial court's reasoning, and that's how I read it, what's incorrect about that?
So point one is it is incorrect to say that there is no discovery in the arbitration. I would point the court on this front to page 5A of the sealed supplemental appendix, and in particular, Rule 14, which breaks the page from 4A to 5A, which states expressly that the arbitral panel may, at a preliminary hearing, establish a schedule for the production of relevant documents and other information.
They may, right? That doesn't sound like a right to discovery.
And provide, well.
That sounds like the arbitral panel made up of BDO partners can decide if anybody's getting discovery. They probably, my guess is they're not going to want it if they've already gotten all theirs and the other side hasn't.
Well, I mean, of course, the parties, both to prove up their claims and to prove up defenses, need discovery. There's certainly nothing in the record to indicate that the arbitral panel here would not have permitted discovery. It is expressly contemplated by the rules, and it is respectfully, Your Honor, just incorrect to say that the rules do not permit discovery. The rules do permit.
Well, I'm sorry, I was speaking about the arbitration agreement, which has no provision for discovery, and the arbitration rules, if I remember correctly, were in your possession alone and were not even provided to Mr. JIA-SOBOTA until, what is it, the end of June?
Well, Mr. JIA-SOBOTA, of course, had access to those rules for the better part of a decade. BDO's position is that the rules are confidential, and just as soon, literally the day of the parties settling on a protective order, BDO provided the arbitration rules, and that appears at appendix page 279A.
Mr. Kimberly, can I ask a question on this point you're discussing with Judge Deal, just about the sequence of events and how whether or not there was undue delay on the part of BDO to constitute the arbitration panel. As I understand some of the key dates, on May 28th is when BDO files the preliminary injunction, as you say, to maintain the status quo. In other words, concern about JIA hiring away employees from BDO. And then on June 6th, I believe, a few days later, there's the arbitration demand that BDO files. And then you said on June 29th, BDO began trying to constitute the arbitration panel. Is that correct? But I guess I'm wondering, was there a point in time, I thought I heard you reference something to this effect, that JIA refused to go to arbitration?
Your Honor, all along, Mr. SOBOTA's position was that he would not participate in the arbitration. So he did not.
All along, if you could just point me to a couple of points in time where there is a refusal by JIA to go to arbitration.
I'm not sure, Your Honor. I have at my fingertips a citation to letter correspondence. It is clear in the parties' filings concerning the November 9th order that Mr. SOBOTA's position all along was that he did not believe that the case belonged in arbitration and was refusing to participate.
I guess I'm trying to get a little earlier in the timeline, like around May and June, when you first make a demand for arbitration and then file the preliminary injunction. Was there, I mean, if just approximate, if you can't at this moment point to a piece of correspondence, was there an email, a letter, or what indication was there that JIA was not going to cooperate or to participate in the arbitration that BDO said they wanted?
I think probably the clearest evidence, Your Honor, comes just 3 days later. It's his July 1st motion for a stay of BDO's arbitration of its own claims, where he took the position that arbitration was inappropriate. And he believed the court not only should decline to compel arbitration of his counterclaims, but should affirmatively stay BDO's pursuit of its own claims through arbitration. And that was on July 1st. Again, just 3 days after the June 29th efforts by BDO to begin naming panelists. I would add, Your Honor, well, just to step back, I guess as a legal matter, again, even if you were First, I respectfully, I don't think that the June 29th effort to name panelists is really the right point to think about whether or not BDO had waived its right to pursue arbitration. I think the filing of the arbitration demand, which is what tips off the arbitration process, which came on June 5th, a mere 10 days after the filing of the complaint, is really the question about whether or not BDO had waived its right. And in this sense, Your Honor, that this case could not be more different than this court's 2020 decision in TRG. And I think it would be helpful just to look very briefly at the facts of that case for contradistinction. TRG, and I'll quote now briefly from the opinion, did not invoke arbitration as part of its first response to Smith's lawsuit. Here, the opposite is true. The very first filing in this case, the caption of the very first filing in this case made clear that BDO's intention all along was to pursue damages and relief through arbitration. It's clear too on page 12A at paragraph 1 and 15A at paragraph 7 of the complaint. It makes clear that this case was never about obtaining full relief. It was only ever about obtaining an injunction to stop Mr. Sabota from stealing employees and clients from BDO, which it absolutely had a genuine interest in.
Let me ask another question, just so I'm clear. The discovery request, and I know there's a long list. How would you characterize the purpose of the discovery request, some of which asked for, I believe, 8 years of prior financial records from JIA? How does BDO view those discovery requests, some pretty cumbersome, if you will, as furthering either the preliminary injunction to maintain the status quo or aiding in getting to arbitration? So,
Your Honor, the nature of the claim here is that Mr. Sabota had engaged in a concealed conspiracy to form his own competing accounting firm and to steal an entire practice, the employees and clients of BDO.
But why was it have that in the preliminary, have that kind of discovery going to the ultimate claim of the breach in the preliminary injunction, as opposed to as part of the arbitration? I get the notion of preliminary injunction. Let's put a halt here for a second so we can get to arbitration. What I struggle with a little bit is the extent of the discovery request. If the goal was to, let's hold off for a second so we can arbitrate this. Just help me understand that. Yeah.
To understand, Your Honor, the full range of clients as to which Mr. Sabota's non-competition agreement within the partnership agreement would have covered, BDO had to understand the full range of clients for whom Sabota had done work. That includes not just straightforward documents in BDO's possession, but also documents and communications in Mr. Sabota's possession, because there was evidence in addition that he had been doing some work without properly recording or accounting for it. The discovery in the case was very narrowly tailored to uncovering the full range of clients and work that were covered by BDO's right under the partnership agreement to prevent Mr. Sabota from stealing that business. I would add, as we noted in our papers, it would be a very strange rule that permitted a party like BDO to seek preliminary relief in aid of arbitration, but to tie its hands and at risk of finding waiver of arbitration and preventing it from vigorously pursuing the evidence and documents and testimony necessary to establish its right to relief under the preliminary injunction framework.
I don't find it so strange, counsel, when the provisional remedy that you seek is so tied up with the merits that you need to engage in months of discovery and that you delay a preliminary injunction hearing that was scheduled for early July to the end of September because you don't have the discovery you need yet. It sounds to me like the benefits of arbitration in that scenario are entirely obliterated by the provisional remedy that you're just running a dual track litigation. I mean, I don't think it's bizarre to say, look, yes, you have a right to ask for a provisional remedy. Oftentimes, those are very legally based requests for injunctions. Sometimes they can be very, very fact intensive and require extensive discovery in the lead up to litigation. But when it is that fact intensive and you need to go through the court process to get months of discovery in order to decide the provisional remedy provision, that is inconsistent with an intention to arbitrate, because you've already exploited the court process to, you've basically litigated the whole thing in court. I don't find that odd.
Well, Your Honor, I guess I have two reactions to that. The first is from the position of a litigant facing this choice. It is a completely unadministrable standard. There is no way for a party like BDO, or for that matter, Mr. Sobota, if the tables were turned, to know whether or not pursuing preliminary relief is going to result in waiver.
Oh, sure. I mean, I appreciate the administrability point. There might be hard cases. I'm just suggesting this isn't one of them. That you could have arbitrated the entirety of this thing from between May and the end of September by the time you got a ruling. Maybe, I don't know why you didn't.
Well, we didn't, Your Honor, because Mr. Sobota was refusing to participate in the arbitration. And as I say, as soon as we began the process of pushing forward with the arbitration effectively in his absence, which the rules do permit.
In October.
He sought a court order from the Superior Court to stay arbitration, which in turn was granted. Obviously.
Yeah, you had dragged him through 4.5 months of litigation by then, counsel.
Your Honor, we had filed a motion, a demand for arbitration right out of the gate. And
not taking the steps necessary to begin it because you preferred to stick with with the provisional discovery.
Your Honor, respectfully, I just don't think that's accurate. We could not have gotten a injunction from an arbitral panel.
Yeah, you could have gotten a ruling in that time. I mean, you didn't need an injunction.
Well, no, we do. I mean, we did need an injunction, Your Honor. The point is the arbitral panel is designed to award damages to BDO, both as specified in the contract and as it is entitled, as it demonstrates in the evidence. We were not seeking a damages award in court. We were seeking just a court order to prevent Mr. Sobota from continuing to lure away employees and clients of BDO. That was not relief, practically or legally, that was available to us without an actual arbitral panel. And we couldn't have an arbitral panel unless Mr. Sobota agreed to participate in the process, which he steadfastly refused to do. So we're stuck then in a position. Mr. Sobota,
this is very interesting, counsel. I just want to ask a question about this. Your position is not just that you couldn't have gotten the provisional remedy from the arbitrator, but you couldn't have gotten the end remedy that you wanted, which is not a preliminary injunction, but was a bar. It was effectively a legal ruling on Mr. Sobota continuing, to work with these clients. I don't know exactly how to put it, which makes it sound like those claims just weren't appropriate for arbitration to begin with. I mean, you wanted a preliminary injunction, but then I assume you wanted the arbitrator to adopt that preliminary injunction and make it permanent.
Your Honor, what we were looking for in the arbitration was an award of damages, which was not something we were seeking in the litigation. And again, the litigation was only ever about getting a preliminary injunction. It is true, of course, that we sought discovery, but the right to seek preliminary injunctive relief, which is specified expressly in the terms of the agreement itself, is also expressly protected by New York law twice over in case law and statutory law, would mean nothing if we couldn't seek discovery in civil litigation to prove our entitlement to relief on the PI. The idea that we can come to court asking for a PI but not get discovery to support it would make the right entirely meaningless. Again, I think this case stands in stark contrast with every other decision in which a court has found waiver. I would again return the court to TRG, where before the defendant even raised the notion of arbitration, it had sought dismissal on the merits. It had
again, the defendant. always the defendant in these cases.
Well, but it's true, Your Honor, that was a case about the defendant, but
It's true that they're basically all cases about defendants because it's weird to initiate litigation if you want to arbitrate. It's weird to initiate litigation before you have any demand for arbitration if that's what you want to do.
Your Honor, respectfully, that is not in keeping with certainly my experience or the experience of BDO. And indeed, I would point the court to New York Civil Practice Law and Rules, Section 7502, which notes expressly that a court, quote, may entertain an application for a preliminary injunction in connection with an arbitration that is pending or that is to be commenced inside or outside of the state. It is entirely routine to make the first step when one realizes one is being wronged to obtain a court order to maintain the status quo before further irreparable harm can be inflicted. And again, a mere 10 days later, we commenced the arbitral proceedings with a demand in arbitration. In contrast, in cases like TRG, to address Your Honor's comment about the fact that those involve defendants, I think nonetheless, the point bears on the relevance of the decision on the temporary restraining order. The idea reflected in TRG and other cases is that you don't want either a defendant or a plaintiff, any party, to be able to test the waters in civil litigation, get decisions on the merits, and then if they don't like those decisions, change course and decide after months of litigation that they're going to turn to arbitration instead. That does not at all describe what happened with the TRO for two reasons. First, as I noted, we had commenced arbitration before the TRO decision came down, and the Superior Court, for its part, completely missed that fact. Second, the motion to compel Mr. SOBOTA's counterclaims to arbitration would have had to have been filed within a mere 6 days of the filing of the answer and counterclaims in order to avoid a situation where the motion was going to follow the TRO. We moved within 18 days of the filing of the counterclaims. That is a diligent pursuit of our right to arbitrate those claims. The idea that a party has to move more quickly than 18 days, I think is just, to say that amounts to waiver is, again, to reduce the arbitration right to a nullity. And again, bear in mind that the TRO, in as much as it was a merits decision at all, and of course, precedent is quite clear that preliminary decisions like this are not actually complete decisions on the merits. They bore only on BDO's own claims and not on Mr. SOBOTA's counterclaims. So it would just be inaccurate to suggest that what was going on here was that BDO was trying to test the waters, would have stuck with civil litigation if it had turned out well. It wasn't even the sorts of claims and allegations necessary to take that path weren't even present in the complaint, because again, all the complaint asked for was a preliminary injunction in aid of arbitration. And the notion that this kind of conduct is akin to the conduct in cases like TRG, where the question of arbitration isn't even raised in a single filing until 5 months after the commencement of the suit and numerous merits decisions and hearings before the judge, I think is just it's not an accurate way to think about what actually happened in this case. Every single filing BDO filed in this case referred to and protected its right to pursue arbitration, consistent with the terms of the agreement, which again, Epic Systems and other cases instruct this court to apply vigorously.
Right. I know you reserved some time for rebuttal, I believe 4 minutes for rebuttal.
Thank you.
And so we'll hear from you in rebuttal and like to hear from the appellees at this time. Thank you. All right, Mr. Walsh, thank you.
Sorry, Your Honor, just making sure I was unmuted. Good morning, Brian Walsh on behalf of appellees. May it please the court. Appellees asked this court to affirm the Superior Court's ruling that BDO's conduct before it, seeking a ruling on the merits of appellees' counterclaims, its substantial and overly broad discovery conduct, along with its delay in seeking to compel arbitration to allow the Superior Court to issue a partial ruling on the merits, was contrary to right to arbitrate, and therefore BDO waived its right to arbitrate. Further, we ask this court to affirm the Superior Court's November 2020 decision, which simply reaffirmed its earlier ruling on a waiver. A lot has been talked about TRG, which I believe is directly governs this case.
Yeah, Mr. Walsh, I want to focus a little bit more on Mr. JIA-SOBOTA's actions. We've been talking about a timeline with respect to BDO's actions. Mr. SOBOTA, I assume, received the June 5th, well, first of all, the May 28th preliminary injunction filing, and then the subsequent June 5th demand for arbitration, correct?
Yes, the complaint was on May 26th. Then on May 28th, they filed for a PI.
Right, and then there was a June 9th filing on the part of BDO trying to constitute an arbitration panel. What was Mr. JIA's response? As I understand it, and as we've heard the appellant say, Mr. JIA-SOBOTA, I'm going to say JIA for short, I apologize, refused to go to arbitration. And then on July 1st, filed a motion to stay the preliminary injunction and the other efforts, presumably, to get this arbitration going. So it seems odd to me that the argument that the appellees then make is that BDO waived its arbitration rights.
Well, I think the timing is important. First, Your Honor, I believe it was June 29th that they tried to commence the arbitration panel. And that's important to note. The complaint was filed at the Superior Court on May 26th. We were not able to do anything because they held hostage essentially their rules. I understand that their position that Mr. JIA-SOBOTA could access them at any time while he was still an employee. I'm not sure if that's true or not, but why would he when he was an employee? I don't and was never asked, as I'm aware, to serve on one of these arbitration panels.
Oh, well, he was a partner.
He was a partner, yes.
He was a partner.
Yeah.
All the documents of the partnership. And it seems to me that an arbitration clause that's a part of the contract or partnership agreement is critical. I struggle with Mr. JIA's claim of ignorance about arbitration as a part of, he wasn't just a low-level employee, he was a partner of this establishment. So you're gonna have to do more to persuade me about this notion of the rules being held hostage, particularly when there's a demand on June 5th. If it wasn't clear from the filing of the preliminary injunction to maintain the status quo, it seems to me the June 5th demand for arbitration was pretty clear. And then certainly the June 29th attempts. So I'm skeptical.
Oh, well, hopefully I can dissuade that skepticism. I mean, on June 5th, when they filed the arbitration demand, we asked for the rules and were told we could not have them until there was an order put in place so that we would be provided them under seal. So at that point, nothing could happen in the arbitration because we had no idea what we were supposed to do under the rules, which we were not provided. And during that time period, they had filed the motion for PI and their motion for expedited discovery. The TRO hearing goes on.
Well, is there some communication that says, hey, we're ready to go to arbitration, we just need to know what we're supposed to do? Or was there a denial, it seems to me, or refusal to go to arbitration? Because again, like I'm saying, the rules to me were not some mystery, particularly from a partner for 10 years of BDO. But was there a refusal to go to arbitration?
At no time did we refuse. We attempted to do whatever we could do in terms of proceeding with the arbitration all along. Every time we sent something to BDO or to the arbitration administrator that they appointed, we reserved our right that said we don't think this is appropriate, but complying with once we got the rules, we said, okay, our response is due within X days. So we sent in a response to their arbitration demand, and in the cover letter, I believe, reserved our right to say that we don't believe this is properly. And then once they requested to try on the June 29th, once they tried to convene a panel, we attempted to negotiate with them and objected to the people that they proposed for the arbitration panel and tried to counter.
Okay, so everything that you said so far, Mr. Walsh, is to me is consistent with appellant's position that they were pursuing arbitration, and I don't mean to suggest that Mr. GIA didn't have a right to question proposed members of the arbitration panel or to raise concerns, but I don't see how that equals an argument on the part of Mr. GIA that BDO waived its right or desire or intent to go to arbitration. It sounds like this process to get to arbitration was ongoing. There was never a deviation from that. And some of the delays, valid as they may be, are attributable to GIA's exercising and raising questions that are not unreasonable. We don't like this arbitrator. We propose that one. We want to file a counterclaim. I mean, those don't seem to be unreasonable actions on the part of Mr. GIA, but they don't equal a waiver or a deviation or a lack of intent, in my view, on the part of BDO to pursue the arbitration that they, from the outset, said that they wanted.
Well, I think looking at the totality of circumstances, BDO could have at any time initiated this arbitration without Mr. JIA-SOBOTA under its own rules.
Well, you just said that they couldn't because Mr. GIA didn't understand the rules.
No, we didn't understand the rules until the 22nd, at which time we got them. And quite frankly, how
do they have an arbitration by themselves, I guess?
Their rules contemplate that specifically. So their rules specifically contemplate having an arbitration by themselves. We could object. Once we objected, it sort of stalled out the arbitration process. They didn't move forward. They didn't press forward. They could have pressed forward without Mr. JIA-SOBOTA. They had the right to do that. Quite frankly, I think as the Superior Court found, what they did was they filed their complaint at Superior Court. They filed their PI motion. They filed their motion for expedited discovery in support of that PI. They filed TRO, which if you want emergency relief, generally, in my experience, I file a PI with a TRO. But here they waited to file the TRO until after they got teed up their motion for expedited discovery, because what they really wanted was a discovery, which we didn't even know they weren't entitled to. They say, well, it says they may
also wait to file the TRO until after Mr. GIA filed his counterclaims.
I'm not sure that, no, Mr. JIA-SOBOTA, they filed their TRO before Mr. JIA-SOBOTA filed his counterclaims. So
Mr. Walsh, I wonder if you want to concentrate on what I think is probably the only really potentially solid ground for claiming waiver, which is the extent of discovery.
Yes, Your Honor.
Because what you're really saying is, regardless of whether or not BDO wanted to arbitrate, by their actions in discovery, they have waived it. Because I don't think there's any question that they wanted. Everything indicate they were proceeding on a arbitration track, at least in my mind. These arguments about who filed what when is maybe important, but I think as Judge Deal mentioned, that the waiver has to come from the discovery, or at least that's the basis of the fundamental basis of it. And how does that ground marry up with the two things? First of all, that to get a preliminary injunction, one of the elements, as I understand it, is the likelihood of success on the merits, what the harm is, that sort of thing. And I don't hear you saying that you cannot have any discovery in connection with a preliminary injunction. So what we're really down to is what happens over and over again in litigation, people saying, too much discovery, you're going beyond what it is that's required. And courts over and over again saying, discovery is an open-ended process. You can if there's any conceivable link to what you're asking for, if the other side feels that it's been prejudiced, they can file objections. The trial court can rule on it, and whether or not it's within the scope of preliminary injunction. And the trial court never really says this discovery went too far, that discovery went too far. And I just have and the background, of course, are two things: the strong emphasis on arbitration, and secondly, this explicit provision in the arbitration provision agreement that you can seek a preliminary injunction with everything that goes with it. So I'm trying to figure out where what you would say the dividing line is between permissible discovery for PI and what happened here.
Yes, Your Honor. And I think TRG addresses gaming the system at the court, and part of that, obviously, a big part of that here was the discovery. And I believe wherever that line is drawn, in this case, looking at the totality of circumstances, this is a PI in sport, allegedly in support of an arbitration, and the arbitration. And the issue is, the PI is whether or not he's stealing employees or whether or not he's stealing clients. To determine that, I think the Superior Court reasonably found that issuing 11 third-party subpoenas, issuing voluminous interrogatories and document requests, requesting 4 days for a hearing in chief, for the case in chief, issuing noticing 8 depositions, taking 6, all the motions practice associated with that was unnecessary. And to give examples, they issued you find this on Appendix 2254A, first a subpoena to Kodak for communications with Flow, which is another company, and Flow's legal counsel. None of those parties are party to dispute. Kodak was a hypothetical, at best, client of BDO at some point, and later, and Flow was a client of BDO. So it's that sort of gives you an example. Then in the 30s,
this is the grist of the mill in discovery practice. I mean, that's the fight all the time.
Oh no, Your Honor, I agree.
Maybe discovery is the lousy system. It may be no good. Maybe one of the advantages of arbitration is you don't get all tied up in discovery. But to look at the way life operates, it seems to me that unless you can have a really detailed showing of the total irrelevance of what was going on, to evidence an intent by the plaintiff seeking PI to how shall I say, negate the normal practice of arbitration by exploiting, so to speak, the court system for finding out things which were not relevant to the PI, even though they were relevant to the arbitration issues themselves.
Well, and I agree. I think we have that here, Your Honor, just in the volume. This was not an FCTC antitrust case. This was a breach of a partnership agreement. The copious amounts of discovery, the 30B6 that they issued to Everglade following the waiver ruling included a request for financial and operational performance of Everglade to date and for 2021 and beyond. That's clearly focused on monetary damages, not which would have been something they could have then taken back to their arbitration panel. That would have been, again, where I understand they may have discovery there. I question whether or not they would have ever have allowed discovery when they already had everything they needed, especially during the whole time. To put in, again, just to add to the perspective here, while they're seeking all this discovery, we're issuing discovery at the Superior Court as well, and they're fighting back and refusing to comply because they say none of our discovery is necessary for the PI. They refuse to comply until we file a motion to compel, which the judge eventually granted, saying that yes, you're entitled to discovery too. So their plan all along was to get as much possible discovery at the Superior Court, deny us discovery, then go back to their secretive BDO only arbitration panel with their discovery after having allowed us none, and deny us the right to have any discovery and game the system. They had, if they were interested in compelling their own claims to arbitration, they could have filed a motion to compel their own claims, which they did not do. If we were so obstructionist, they only filed a motion to compel Mr. JIA-SOBOTA's counterclaims. I think the Superior Court correctly looked at all the factors and found that the behavior by BDO altogether violated the intent to arbitrate and demonstrated that they were not serious about arbitration. They were serious about getting discovery and maybe one day going back and using that against Mr. JIA-SOBOTA when they had taken advantage of the court. And unless there's more questions, I see my time is up. And thank you, and ask that the court affirm the decision.
All right, thank you, Mr. Walsh. Mr. Kimberly, you reserved a few minutes for rebuttal.
Thank you, Your Honor, and I'll try to be short and direct. First, I'd like very briefly to explain a little bit more about the delays in the case. First, I've been reminded by my colleagues that the delay in the proceeding to the PI was a function largely of two factors. The first is that there was a change in judges from the temporary restraining order proceedings to the PI proceedings. And that change implicated sort of reset all the progress we'd made with the initial judge. But perhaps more than that this was now mid-2020. This was right at the onset of the pandemic. And our hope had been that we would be able to have an in-person PI hearing, which now as we sit, having this hearing remotely seems somewhat aspirational. But at the time we had a sense that a slight delay to get an in-person hearing and allow the cloud of COVID to dissipate would have been worth it. We know better now. The delay in setting the arbitral panel, I think as my friend on the other side has just laid out, the parties were backing and forthing about establishing a panel. BDO could have pushed forward and simply said that Mr. SOBOTA was being obstructionist and not awaited his input on the panel. But if we'd done that, there's no question the award would have been subject to litigation for unfairness later on after an award was entered. And so our effort was to establish a panel with him, all conduct of which was consistent with our right to arbitrate. And coming back now to Judge Stedman's line of questioning, I guess I would put it this way. It's just not clear to me based on the Superior Court's holding or my friend's argument, what it is that BDO was supposed to do differently. It was entitled under the terms of the agreement to seek a preliminary injunction. It was entitled to the same under well-settled New York case law and New York civil practice law and rules 7502. So it was permitted to come to court to seek a TRO and preliminary injunction. It follows necessarily that discovery is an incident to requesting that relief. Was BDO to attach to each discovery request a request for an advisory opinion from the court that if it pursues this discovery, it will be found to have waived the arbitration right? Obviously, that's not a meaningful solution. So it would put parties like BDO seeking to pursue their rights to preliminary relief under arbitration clauses and also to pursue arbitration in parallel in the impossible situation of having to guess how much is too much. And I submit to you, Your Honor, that claims like this are factually complex. And the fact that a defendant is wronged in the course of a concealed, factually complex scheme should not mean that by coming to court to get a injunction in aid of arbitration, that it necessarily should or ought to assume the risk that it will be denied the right to arbitrate after all. That would reduce the right to seek preliminary relief.
What sense, can you just explain to me in what sense the injunction that you were seeking would have aided arbitration?
And I'm sorry, Your Honor, you cut out a little bit there.
I understand the caption and your description of the preliminary injunction was something in aid of arbitration. I just want to understand in what sense you think the injunction would have aided arbitration. Why was the injunction necessary as prior to the arbitration? Why was it a necessary thing to help arbitration move along? They kind of seem like separate things in my mind.
Well, I think the idea, Your Honor, is, and it's a natural element of civil litigation as well, that when a defendant is engaged in an alleged course of conduct that is causing irreparable harm, and stealing employees and clients, I think, is a pretty classic example of irreparable harm that can't be undone, that a court's a plaintiff's first hope is to get a court order that just hits the pause button on the status quo and prevents further harm. That is not possible as we laid out in the introduction to our opening brief. That is typically not possible in an arbitration for the reasons that you've heard us discussing here today, that it takes time to set up an arbitral panel. And therefore, just to put a hold on what's going on of the claimed wrong, to allow the parties breathing room to establish an arbitral panel and get the process started is a much, we think, certainly it's a procedure that is contemplated by the parties in the agreement. It's contemplated by the adoption of New York law, which also expressly permits it. The notion of preserving the status quo to allow the parties to work through their dispute, I think is a sensible approach, and as I say, one reflected in the terms of the agreement.
But why did it take you 3 or 4 months to engage in this arbitration in the discovery process? I mean, if this harm is occurring, you'd think that now it's important, of course, that you lost the TRO, because that indicated, hey, we really need more information if we're going to get a PI. But when was it, June to September?
That's exactly right, Your Honor. I think we took it on the chin with the TRO. We went in without any meaningful discovery at all, and we were told you need a lot more than this. So we refocused our efforts to obtain a PI on obtaining more information. I think the delay also is in part due to, as I mentioned, the COVID pandemic, which had thrown everything up in the air. I mean, this was when offices were first closing and courts were closing, and proceedings like this were complicated significantly in a way that they are no longer. And I would say also, obviously, the proceedings were contentious. As my friend on the other side noted, we did resist discovery requests that we argued were outside the scope of our request for a PI. The litigation all along was only supposed to be about obtaining a PI to maintain the status quo. Our position was that the counterclaims should have been compelled to arbitration, and therefore that any discovery on those claims should have taken place in the arbitral proceedings themselves. The back and forth of the parties on those issues ended up taking time. But I do stress that all of the discovery that we requested was narrowly tailored to, which is not to say that it wasn't, that the requests were minimal. They were not minimal requests. We acknowledge this, but that is a function of the nature of the claim, not any intent to take advantage of civil litigation rather than arbitration. Aside from that, the requests were all narrowly tailored to specifically the relief that we were requesting on the PI and nothing broader than that. And all along in parallel, we were working as diligently as we could to set up the arbitration and get moving until the judge ultimately told us we had to stop, which of course we did at that time. And ever since then, of course, we've been sitting tight, and the case has not been proceeding. And more than anything, we would just like a remand to the Superior Court with instructions to compel arbitration of the counterclaims and lift the stay of arbitration of our claims, which, as I mentioned, was already commenced on June 5th.
All right, thank you. We'd like to thank both or all parties for your briefs, and both parties for your arguments today are under advisement. And you're free to exit our virtual courtroom at this time. I see Mr. Friedman and Mr. Marks. Are you able to see and hear us? I think Mr. Marks may still be trying to connect.
Apologies.
All right. Good morning, Mr. Marks and Mr. Friedman. This is our third case and final case this morning in the matter of Paul Knight et al. Versus Deborah, I believe the pronunciation is NEIPRIS or NEIPRIS?
NEIPRIS, Your Honor.
NEIPRIS, okay. Are parties ready to proceed?
Yes, Your Honor.
Okay.
Good morning, Your Honor. My name is Philip Friedman. I'm a counsel for the appellant attorneys. This is a case where the appellant attorneys prosecuted a very difficult and novel case against Iran, in which they obtained a judgment of $62.5 million for their clients, as well as ultimately secured a payment of nearly $6 million.
I didn't mean to interrupt you, Mr. Friedman. I apologize. I just wanted to see if you plan to reserve any of your time.
Yes, I'm sorry, Your Honor. I would like to reserve 3 minutes.
Okay, thank you.
As I was noting, this was a difficult case. Ultimately, the appellant attorneys secured payment of nearly $6 million from the Victims' Compensation Fund, from which they rightfully claim fees. But because of the tortious acts of Deborah NEIPRIS, an irreparable rift developed between the attorneys and the clients, which ultimately forced the attorneys to sue their clients in arbitration before ACAB, which the attorneys won at considerable cost. A tortious interference claim was simultaneously filed with the ACAB proceeding, but stayed as part of an agreement between the parties pending the resolution of the ACAB proceeding itself. Once the attorneys prevailed in ACAB, they then pursued their case in Superior Court. And as a result of the trial court's improper dismissal of the single count complaint against NEIPRIS, NEIPRIS will escape completely unscathed for the tortious act she committed against the attorneys. We believe there are 3 cases that control the disposition of this action, either taken alone or read together, compel a holding that the lower court erred as a matter of law. The first case that the court—
Counsel, before you get into the cases, I'm sorry to cut you off, but could you just explain to me one thing? It's in ACAB, you sought, and Ms. NEIPRIS was a party, you sought to have your expenses from the arbitration itself. You sought to collect those, including from her and the other groups. And you didn't get them. Why doesn't that foreclose you from then going back and seeking them again?
Well, Your Honor, I would respectfully disagree with your characterization of what we were entitled to do in the ACAB proceeding.
I didn't say anything about what you were entitled to do. I said what you did is you tried to get them. I didn't say that you were entitled to do it. I said you tried and you didn't get them.
No, but I respectfully would take issue with the characterization that we tried to get them.
Okay.
There certainly was a boilerplate pleading for fees that were incurred in the arbitration, but respectfully, this court's ruling in Ludwig and its interpretation of ACAB proceedings itself specifies that ACAB is a tribunal of very limited jurisdiction that is limited to the fees paid, charged, or claimed for legal services against our clients in the case that we actually pursued for them against Iran and ultimately obtained collection in the Victims' Compensation Fund. The ability to actually pursue a claim for fees that were incurred in the arbitration itself, or for that matter, to pursue any ancillary action, was expressly prohibited by ACAB rules. The reasons the appellant attorneys simultaneously filed a claim in Superior Court for tortious interference and ultimately stayed the case was because the damages that they would be entitled to receive in the tortious interference claim were not knowable until they ultimately prevailed in the ACAB proceeding itself. If we had lost in the ACAB proceeding— I'm sorry, Judge Stedman, did you have something?
Yes. What I want to ask you is this. is it really that clear that in the arbitration proceeding, the arbitrator could not have dealt with your totality of field of costs and fees, not just the fees that you were fighting about with respect to whether or not it was to be quantum merit or a percentage, but in addition, the fees that you were incurring as a result of the arbitration itself, which is what, of course, you wanted the trial court to give you. Why is that so clear that in this circumstance, the arbitrator could not have done that? And by the way, when you asked, as I understand it, that the arbitrator do that, and the other side said, there's no merit, not that anybody was saying you don't have any jurisdiction. Now, granted, the arbitrator did not get to that point, but hey, you didn't ask them to.
Well, I would respectfully disagree with the characterization that there was ever any opportunity to actually claim and seek fees for those fees that were actually incurred in the arbitration proceeding. This court had noted that under the rules of ACAB in the Ludwig case, the body's jurisdiction is limited to disputes about the fees paid, charged, or claimed. And it's precisely that limitation that the appellant attorneys took the course of simultaneously filing a separate tortious interference claim in the Superior Court. And with the knowledge that that case could never be pursued and the underlying claims could never be litigated in the ACAB proceeding, the parties agreed to stay that Superior Court case pending what happened in the arbitration. Since the arbitration following the ACAB rules could never actually reach either a separate claim or the fees that were actually incurred in pursuing the ACAB proceeding, there was no effort to actually pursue those fees. There was no evidence presented with respect to those fees. There was no post-trial motions with respect to those fees. It was clearly limited and only limited to the fees that were incurred and to which they were entitled under the contingency fee agreement that they originally had with their clients. The trial court, the lower court's reliance, it partially recognizes that Ludwig is certainly applicable. It had no problem understanding that ACAB was an area where there were limited ability to pursue those proceedings. Instead, it relied on another case that this court decided years earlier in Rosenthal. And the Rosenthal case that needs to be reconciled with Ludwig is basically says that there's a wrongful exception to litigation standard can be met if you meet 3 prongs. The lower court recognized that we met 2 of those. One was that we incurred fees in a prior action. We noted in our First Amendment complaint that we incurred several $100,000 of fees in pursuing that case. It was also had no problem making a determination that
I know it's the third one that matters, whether or not whether or not this was against a third party.
Correct. And
ordinarily,
excuse me, Your Honor.
Ordinarily is in there. Now, in this particular case, the third party, so to speak, Ms. NEIPRIS, was there at the arbitration proceeding. She was involved with it a lot. She was sitting right there in the arbitration proceeding.
She was,
and therefore, the question seems to me would be whether or not the arbitrator could, if asked, and he was asked by you, but you never pressed the point, to clean up this whole process of fees and decide whether or not you were entitled to the $400,000 that you had to expend in order to collect your judgment, even though you lost at the arbitration proceeding. on your argument. You won in the sense you got the money, but you lost on the argument you were making.
Well, I would respectfully disagree with the court's characterization that an argument with respect to fees that were incurred in pursuing the ACAB case were ever made. They weren't. And whether or not Ms. NEIPRIS was a party in an individual capacity that would enable her to satisfy what's called the second prong of the wrongful exception to litigation is a question that is in dispute. And what the trial court has done in basically making a characterization that Ms. NEIPRIS was acting in some sort of agent representative capacity and individual capacity and successor in interest is a mishmash of legal determinations that actually turned 12b-6 on its head. She never construed the facts that were pled in the First Amendment complaint in the light most favorable to the plaintiff, and the allegations that were required to be taken as true. There are critical timing issues with respect to what role Ms. NEIPRIS was playing and when. She professed to have absolutely no personal or financial stake in the litigation. And by her own admission, that would question what standing would she ever have as an individual plaintiff that was commensurate with what she was being sued at in the tortious interference claim, that she had any standing as an individual in an individual capacity to actually appear in the arbitration proceeding. She didn't.
Look, individual capacity, representative capacity, or whatever, she was a party to those proceedings in the sense that she was there, she was participating. She was not a third party. So doesn't it come down ultimately simply to the question of whether or not you can maintain, and you have a pretty good argument to maintain, even though she was a party,
right? Well,
you would be unable in the arbitration proceeding to press the claim that you are now pressing.
Well, I think, Your Honor, it's critical in what capacity she was actually appearing. What is the purpose of the second prong in Rosenthal? It's to prevent where all parties are present in action, like the federal court in the Rosenthal case, of getting a second bite of the apple in another proceeding.
Exactly.
Where the claim could have or should have been brought in the first instance.
Exactly.
Exactly. So in this matter, the appellant attorneys, because of the limited jurisdiction and scope of ACAB,
we're back
as
to
interpreted by this court.
Okay,
but the court interpreted, it's a court of limited jurisdiction. We didn't get 2 bites. We didn't get a single bite. We got no bite. And because of the lower court ruling, we would have no opportunity to ever pursue Ms. NEIPRIS for the tortious acts that she committed against us.
Mr. Friedman, I'd like to jump in and ask a little bit about the tortious interference claim against Ms. NEIPRIS, because I'm not sure I'm understanding what the elements of that claim are, and whether there is. Well, let me just ask the question: is the claim with respect to Ms. NEIPRIS's actions in light of the 2006 agreement or the 2016 agreement?
It's in light of the original contingency fee agreement.
Was that the 2006 agreement?
That's the 2006 agreement, correct. And that agreement entitled the lawyers to a 1/3 claim for any fees that were collected on the judgment that they obtained against Iran. That 33% fee was limited by statute in the Victims' Compensation Fund to only 25%, which is a claim that was made shortly after the clients actually obtained that recovery. So Ms. NEIPRIS was completely aware of the existence of that contingency fee agreement. And this court has said repeatedly, where lawyers substantially perform under a contingency fee agreement, they are entitled to the benefit of the bargain of that agreement itself.
Well, I guess it sounds a little bit to me almost like you're asking us to recognize a wholly new cause of action. Not tortious interference with a contract, but interference with wrongful involvement in litigation, which I'm not sure is a cause of action. Can you help me understand why this
Well,
is not.
the underlying claim, I'm sorry.
Can you just help me understand why this is not a new novel cause of action, given the alignment or relationship of the parties in this action?
Well, I think, first of all, the question about the alignment and role of the parties in this action, I think there's still some confusion about the role of Ms. NEIPRIS. Ms. NEIPRIS claimed all along that she's only acting as a facilitator. All of the claims of her of interfering with the contract with the lawyers and their clients, all of those actions took place before the arbitration proceeding was actually filed, at which time she became a purported personal representative of the estate of Ralph and Helen Goldman. She did not assume that capacity until long after the tortious acts of interference were actually claimed. And then in the actual arbitration proceeding, we even made in the caption, she was an alleged representative of the estates of Ralph and Helen Goldman, because we had no idea what her purported capacity was when she obtained this purported capacity, or what capacity she was actually acting in. So if you take at face value what we have in our First Amendment complaint and our claim of tortious interference, the assertion is that she was aware of the existence of a contingency fee contract, and she made an effort to make her clients forego or breach that contract in lieu of pursuing her actions before another law firm.
Can I ask so let's say I'm not a judge or a lawyer of any stripe, but a friend comes to me and says, hey, I've got this contract with some lawyers. They want 25%, but I'm not satisfied with the services they've provided. And I think they should have done X, Y, and Z, and they didn't. And I look at the contract, I say, yeah, I mean, it kind of seems like they should have done X, Y, Z. I don't think you need to pay them the whole thing. And it says here that you can arbitrate about that. So why don't you use that? I wouldn't pay them. Would I have just committed intentional interference with contract if I had done that and then they didn't immediately pay, but instead decided to arbitrate the fee?
No, we're not making any assertion here that pursuing a case in arbitration and trying to pursue that vigorously gives rise to a tortious interference claim.
And so what more than what I just described? So I read the complaint. I have to say, other than some, conclusory, bad faith kind of language that's loaded in there, I don't see anything other than Ms. NEIPRIS advised them when they asked her to advise them about whether or not they had to pay. And so I guess what more is it that you think the complaint alleges to substantiate a tortious interference claim?
The complaint alleges the existence of a contract. It alleges
that was part of my hypothetical.
Right. It alleges that Ms. NEIPRIS was aware of that contract.
That was part of my hypothetical.
Third,
too.
there's an intentional effort by Ms. NEIPRIS to make her cousins, her family members, breach that contract by making assertions that we had abandoned the clients, we failed to perform certain tasks, we committed malpractice.
I think that was part of my hypothetical too. I said, don't pay it because they should have done X, Y, Z.
Right. Well, so
my hypothetical is an intentional interference with contract.
The hypothetical is that there's an intentional interference with the contract when she says you are not entitled to be paid anything for the services that you rendered. And that is, in essence, based on the decisions made by this court in Kashuba versus Hutter, which makes it unambiguous. If I am an attorney that has a contingency fee agreement, whatever the underlying dispute that the client might have about how well I performed, if I substantially performed every task that was required, which we did, obtained the judgment and ultimately
So if she's just wrong, so if in my hypothetical I say, I think they had to do X, Y, and Z, don't pay them. If I'm wrong about that, that's an intentional interference with contract.
It's an intentional interference of contract to claim we are entitled to no fees whatsoever, because this court has said if I substantially perform, I'm entitled to my fee. And if you pursue litigation in arbitration with the notion that you are entitled to nothing, then there also has to be a consideration. Let's assume for the
It's a very, very simple question. It'll be my last one. Where in the complaint does it's, and this might be in there, I just don't remember it. Can you point me to where in the complaint the allegation is that you said don't pay him a thing?
In the actual complaint, well, we had requested payment after the Victims Compensation Fund was awarded to the family on, I think it was March 14th. We requested payment, and Ms. NEIPRIS refused to make payment to us, and also instructed the JDC, which was at that time the representative of the estate, and Ralph and Helen Goldman, which Ms. NEIPRIS later assumed when the arbitration was filed, not to pay us as well.
I mean, it sounds like your answer is it's not in there.
Well, I think
she instructed them. She said, don't pay what they're asking because I don't think they're entitled to it. And you kept, when I was pushing on the hypothetical, you kept saying, well, she was telling them not to pay a thing. And when I asked where that is in the complaint, so far I haven't heard an answer.
Well, the best evidence that I could point to, Your Honor, is the.
I don't need evidence. I just need an allegation.
Well, it's an allegation in the complaint that we had requested payment. I think that's in our First Amendment complaint at 55 and 56, paragraphs 55 and 56, and that we were denied that payment in those subsequent paragraphs, which required us to file a claim for arbitration to get those fees. What else could we have done? There was nothing left for us to do other than to pursue a case in arbitration, which we won. And
I'm not saying you should have done something different, counsel. What I'm saying is if somebody says that, you know, I don't think they're entitled to their full fee, that doesn't make them, doesn't put them in the position of having intentionally interfered with the contract if they're wrong about that. And if that is what amounts to intentional interference with the contract, that strikes me as a sweeping rewriting of that tort, and a quite dangerous one. So that's what I'm saying. It's not you did something wrong. It's that, yeah, you know, you had to go and work harder to get your fees. Doesn't make her as somebody who has intentionally provoked the breach.
It goes, if your assertion, your hypothetical with respect to the client themselves, I would agree with you, but this is not the client. This is someone who is telling the client you shouldn't pay them anything because they're not entitled to a fee, and who during the course of her tortious conduct had the family members not only terminate their relationship with the lawyers, but actually sought, not even with the permission of the clients, different counsel to pursue the collection efforts. To me, that seems a fairly straightforward claim for tortious interference, where she knows we have a relationship, she encourages people to breach that relationship, and ultimately advises her family members not to pay the lawyers for the fees they substantially perform. To me, that's a straightforward three-pronged assertion of a tortious interference claim. I see my time is up, and I'd like to reserve the remainder of my time in rebuttal, Your Honor.
How did that?
You're on mute.
How did the breach of the 2000? Is my sound on?
My sound was off. I was indicating that we had given pretty generous time to Mr. Friedman, although I know he's reserved time for rebuttal. But Judge Stedman, you have a question? Please go ahead with your question.
Oh, boy.
Go ahead, Judge Stedman, your question.
Is it going? No.
Yes.
It's going? Okay. Can you hear me, Mr. Friedman?
Yes, I can.
Okay, good. Tell me, what is the nexus between the breach of the 2006 agreement and the requirement for arbitration?
The 2006 agreement had a provision in, if there were any dispute regarding the payment of the fees, that they would avail themselves of the ACAB proceedings. So that was specified in the actual agreement itself.
No, but if there hadn't been the breach, there would have been no need for arbitration. Is that your point?
There's certainly, if we had been paid for the services that we performed, there would be no reason for us to ever bring an action against our clients. when the clients failed.
Because you would have got the full amount from the victims fund. Is that it? I'm just trying to understand the nexus.
Maybe I'm misunderstanding your question, Your Honor, but the purpose of filing an arbitration claim against the client was the failure to actually pay us the fee that we were entitled to once they collected judgment, which was done with our assistance from the Victims' Compensation Fund. At that point, under the contingency fee agreement, as limited by the Victims' Compensation Fund statute of cutting the fee down to 25%, we were entitled to that amount. When that amount was refused to be paid, that's when the claim for arbitration against our clients was filed.
But that's what you lost in the arbitration proceeding.
No, we won. We won our arbitration claim.
To your fee under the contract. You were entitled to quantum merit, which happened to be, says the arbitrator, 25%. So what is the nexus? I'm trying to figure out how the breach of a 2006 agreement, which you terminated, led to the arbitration.
Your Honor.
Or are you claiming that she also committed wrongful acts in connection with the arbitration?
No. Your Honor, I respectfully think you perhaps are confusing what we were seeking in the arbitration proceeding. In the arbitration proceeding, we were seeking the fee that we earned in representing them in a case where we obtained judgment against Iran. What we are seeking in the tortious interference claim, which was dismissed by the Superior Court following the arbitration proceeding, was essentially, through the tortious interference complaint, our claim for fees that we incurred in prosecuting the arbitration proceeding that resulted in us obtaining what we were entitled to under our original contingency fee agreement, the 25% award of what was obtained from the Victims' Compensation Fund. There was no effort in the ACAB proceeding to pursue any of the fees that were incurred in the actual arbitration case. And it's our contention under the ACAB rules, as well as this court's ruling in Ludwig, that there was no ability for us to ever pursue those claims for fees that were incurred in the arbitration proceeding itself.
All right. Any further questions at this time, Judge Stedman?
No.
Okay, Mr. Friedman, I understand you reserved time for rebuttal, but we'd like to hear from counsel for appellee at this time.
Thank you, Your Honor.
Good morning. May it please the court. My name is Andrew Marks, and I'm counsel for the appellee, Ms. NEIPRIS. I'd like to start by addressing a couple of the questions and a couple that the panel raised, and a couple of the misstatements by Mr. Friedman. First of all, there was no termination by the family of the contract. The record is clear, and the arbitrator found the agreement was terminated in 2006, April 2012 by the lawyers. So there was no termination or inducement to terminate or any wrongful action that led to a termination. The lawyers chose to terminate it. And Judge Stedman, as you correctly pointed out, as the arbitrator found, that termination resulted in a waiver and a relinquishment of their right to a contingency fee. It is the case that the arbitrator, well, let me say to Judge Deal's point, Your Honor, there was never any allegation, nor could there be an allegation, that Ms. NEIPRIS or the family ever disputed that the lawyers were entitled to quantum merit compensation. If you look at the arbitration award, the arbitrator recognizes there was no disagreement that there was entitlement to quantum merit. The contract, the 2006 agreement is clear. Both parties had an absolute right for any reason, and this is a contract that the lawyers wrote. Both parties had a right for any reason to terminate it. And the lawyers chose to terminate it for their own reasons. Upon termination, that extinguished their right to a contingency fee per the language that they put in the agreement, but gave them a right to quantum merit. I actually want to come back and put a point on that because I want to come back to the statute of limitations issue because their right to quantum merit plays into that as well. But there was no finding by the arbitrator of breach. There was no breach. There was simply a dispute about how do you measure quantum merit in a case like this. The lawyers themselves recognized that this was, in their words, not a hostile or an antagonistic dispute. Rather, it was a dispute that required resolution by a professional arbitrator. We're here today because of unprecedented overreach by the lawyers. It's not enough for them that they've received $1.9 million in fees and a right to future fees if the family gets additional distributions from the victims fund, but they want, in addition, to circumvent the American rule. The trial court properly applied the American rule, properly relied on Rosenthal, and found that Ms. NEIPRIS was a party in all respects to the arbitration. And let me just highlight a couple of points. First of all, she's named in the pleadings, okay, as a counterclaimant, as a respondent. And I want to call to the court's particular attention in the case of Jaffe versus Nacera, and a little mea culpa. We cited Jaffe versus Nacera for the very important point, which I'll come to, which is that a party can't ask for arbitration on an issue and then claim that there's and then claim that the arbitrator doesn't have authority. So Jaffe and Nacera we cited for that point. But in preparing for this argument, I went back to look carefully at Jaffe, and Jaffe is squarely on point with respect to Ms. NEIPRIS' party status. She's named in the pleadings, okay? She's asserted a claim. There was never an objection. There was never an objection by the lawyers that she didn't have standing to pursue a counterclaim. She sat at counsel table for 3 days. The lawyers' counsel in the arbitration invoked the rule on witnesses against non-party witnesses, but they didn't assert it against Ms. NEIPRIS because they knew she was a party. She was extensively cross-examined and she presented testimony, was extensively cross-examined. In addition, the only deposition taken in the entire arbitration proceeding was of Ms. NEIPRIS, and if you look at the transcript of the deposition, it lists her as a party. And I think it just to put a little bit of a bow on it, there was an issue before the trial court. We challenged the standing of Mr. Friedman and Mr. Knight and the other lawyers to bring a claim since the contract was with the law firm of Nossaman, and Nossaman wasn't a party to this tortious interference case. And bear with me a second, I just want to get to my notes here. In there, they took the position that she was bound by the arbitration ruling. Sorry, bear with me 1 second. She was bound. They claimed that she was judicially stopped from challenging their standing to bring this tortious interference claim. And this is their words before the trial court, because she, Ms. NEIPRIS, individually had a, quote, full and fair opportunity to litigate, unquote, and, quote, every opportunity to zealously defend the plaintiff's arbitration action. There is no basis for finding that she was not a party. The trial court was completely correct in finding that she was a party. Now, I want to come to Judge Deal. You raised the question.
I'm a lawyer on that subject.
Yes, please.
It seems to be you put a lot of emphasis on the fact that she's a party. The other side says, yes, but she wasn't a party in her individual capacity because she had nothing to do with the arbitration itself personally. She was only there as a representative. But my question is, even if she's a party, does not Rosenthal address the issue that even if you're a party, you have to have the purpose of that provision ordinarily is to prevent somebody from having a second bite at the apple. But if the appellant is correct in saying that the trial court, the arbitrator could not have adjudicated a claim against her for the $400,000, then she hasn't ever had a chance, or they have never had a chance to litigate against her on that issue. And therefore, she's entitled, they're entitled to proceed. So then I come down to the question again, is it correct that the arbitrator could not have ruled on the $400,000 as a cost to which the plaintiff was entitled of collecting the money resulting from the arbitration itself?
Thank you, Your Honor, for that
When
question.
they asked for it.
Exactly. This is-
In, I think it's paragraph 89 of their statement.
They not only asked for it Your Honor, they not only asked for attorney's fees in their claim, they also reasserted it in response to the counterclaims. So they asserted it twice. And Judge Stedman, two cases in which you were part of the majority decision, the Lopata versus Coyne case and Fairman versus DC case, are dispositive of this point. This court has consistently held that a party cannot assert a claim in arbitration and then claim in later litigation, oh, the arbitrator didn't have authority.
Jaffe, and what's the other one?
It's Lopata versus Coyne, which is 735 A second 931, and Fairman versus the District of Columbia, 934 Atlantic second 438. And that rule that this court has consistently followed, you can't have it both ways. And the notion that there's a boilerplate exception, we made a claim for attorney's fees, but we really didn't mean it. Sorry, there is no exception to they sought it. If the arbitrator had granted their request for fees, we would have been bound by it because we did not contest her authority. We contested on the merits. Now, they chose, and by the way, I appreciate Mr. Friedman's candor. He said they're not claiming there was any misconduct in the arbitration. He's not even claiming that there was a bad faith position in the arbitration. Okay, they decided, they put in their claim for fees and expenses. They didn't pursue it. If after the arbitration was over, if they still felt they were entitled to it, they could have gone back to the arbitrator and said, Your Honor, you didn't decide the fees and expenses issue. We'd like you to decide it. They didn't do that. They submitted, it was by consent of the parties, the issue of entitlement to fees and expenses was submitted. Now, first, let me say, the ACAB rules do not, and I've been an ACAB arbitrator myself for 30 years. The ACAB rules do not address the issue of whether an arbitrator in an appropriate case can award fees and expenses if there's bad faith. But it doesn't really matter, okay? Because even if the ACAB rules had specifically said it doesn't have authority, the ACAB rules operate by contract, okay? They're like any other arbitration rules, and the parties can expand the scope of an arbitrator by agreement, by consent, by conduct. That's exactly what happened here. So Rosenthal is squarely on point. Just from the context of Rosenthal was there was a prior decision by a Southern District of New York that granted the Sonnenschein firm fees, contingency fees. It was remarkably similar. And then they came and they filed a tortious interference case against the law firm that had been claiming the fees, a competitor. By the way, dramatically different, of course, because Ms. NEIPRIS, it is conceded, had no financial stake whatsoever. She's the only party in all these proceedings. She had no stake. Whichever way the arbitrator decided, for the family, against the family, Ms. NEIPRIS wasn't paid anything. She had no financial interest. This looks, Judge Deal, I was going to pose to the court the exact question. If I am asked by my sister, what do you think about this lawyer's claim? And I tell her, I don't think he's entitled to it. or a doctor's fee, or a contractor, or if a member of this court is asked by a cousin or even a friend, what do you think? What should I do? That's not a tortious interference claim. There's no improper conduct by advising someone. I mean, this case brings to mind the adage, no good deed goes unpunished. Ms. NEIPRIS was helping her Israeli cousins who had suffered the trauma of the killing at the hands of terrorists of David Ben Raphael, cousins who had no experience with the American legal system. And without any financial compensation, without any interest other than the best interest of her cousins, Ms. NEIPRIS helped navigate the situation with the lawyers. And by the way, as the record establishes, there's a separate.
Mr. Marks, remember, we are dealing with a 12B6 dismissal on a complaint.
Yes, Your Honor.
Where you take all the allegations as true. I think a lot of what you're saying is quite correct, but I'm not sure that it's part of a 12B6 examination.
Well, look, if I may, Your Honor, first of all, this court's jurisprudence is clear. First of all, the arbitration award itself is certainly part of the complaint, and much of what I said is established, is there. But secondly, everything in the joint appendix is properly before the court, and nothing I've said is not supported by the joint appendix. The court can take judicial notice of other litigation proceedings, and that includes the arbitration filings. So I don't think I really have gone at all beyond the record that is properly before the court on the 12B6. But what is clear from what is properly before the court is, in addition to the fact that that Ms. NEIPRIS was a party in all respects, and Rosenthal and ACAB was, whether it had inherent authority, as all arbitrators, by the way, we cited case law that all. I'm sorry.
Briefly, I'm sorry, when you said Ms. NEIPRIS was a party in all respects, what was her role before the amendment for assignment of judgment? Was she still a party at that point in time?
Yeah. Well, there was no
that was recognized under law, and how would you describe it?
Sure. There was no arbitration, of course, at that point. So the arbitration took place in 2019. The assignment took place in 2018. So, but she was the agent and representative. The lawyers themselves, in the termination letter, which is absolutely properly before the court as part of the 12B6 record, they wrote, when they terminated the contract with the clients, they didn't write to the clients. They wrote to Ms. NEIPRIS as the representative of the family. And they asked her as the authorized representative to transmit it. I mean, and when they went to schedule the arbitration, okay, the negotiation of the arbitration, of the agreement arbitration, was with Ms. NEIPRIS. Look at Mr. Knight's February 2019 letter expressing pleasure that Ms. NEIPRIS, on your behalf, he writes to the family, has agreed to arbitration. And the case law of this, I know that the trial court didn't reach it, but her status as an agent and representative, is dispositive of the tortious interference claim, because an agent can't interfere with her principal's contract. Judge Stedman, again, a case that you were on the panel, the Press versus Howard case establishes that. But Judge Blackburn-Rigsby, she was a party because they had made assertions against her, and she joined the family in asking the arbitrator to decide that there was no contractual right to a contingency fee. And the arbitrator rejected. The lawyers made that claim in the arbitration. The arbitrator rejected. So she had a right, and the standing in an arbitration is not the same as standing in a court. Parties can consent, and she did file a counterclaim. There was never an objection by the lawyers, and therefore she had status in all respects, and everything about the conduct. And as I said, even the lawyer's own argument before the Superior Court. Can I make just, I know my time's up. I'd be delighted to answer any more questions, but I want to make one other point, because it's another point that I don't think we had a chance adequately to make. Mr. Friedman, everything he said, Judge Deal, in response to your question about what is it that she did that looks like improper conduct or a tort, what can you even craft here? All of that took place before 2012. There's no allegation here that she's done anything improper since 2012. Mr. Friedman said, well, she somehow induced them to terminate the contract. I don't know, he can explain it on reply. But the statute of limitations for tortious interference claims is 3 years. And the case law in this jurisdiction, it runs from the time of the termination of the contract or the wrongful act. The lawyers make an argument, well, we didn't know that the family was going to recover money. The reason that argument doesn't fly is once there was a termination, there was an inherent harm. Once they terminated the contract, the inherent harm was they no longer had a contingency fee right. They had a quantum error right. But secondly, the other point I want to make, the lawyers rely on a case in Maryland called Samoa, I think I'm pronouncing that right, which they say says that a lawyer can't sue for quantum error until there's a recovery. Samoa doesn't stand for that. Samoa says when a lawyer is wrongfully terminated, they have to wait. Oh, I'm sorry, when they're properly terminated, they have to wait. But the case, there are two cases in Maryland, the Skeens case and the Brault-Graham case, and I'd just like to give the court those two citations, hold that a lawyer has a right upon the termination of a contingency fee contract, has a right immediately to bring a case for quantum error. Sorry, let me just grab that citation if I can. Bear with me sorry, I'm missing that one citation. If you'll just bear with me 1 second here. In any case, Skeens and Brault-Graham, Court of Special Appeals, Brault-Graham, the Skeens case, which preceded Samoa, hold that a lawyer has a right. These lawyers had a right. If they thought the contract in the 2006 fee agreement was wrongfully terminated by themselves, they had an immediate right at that point to ask for quantum merit based on the hours and the time and expenses they had spent and incurred. So there's no tolling of statute of limitations for a tortious interference claim for quantum merit to wait for a recovery. They had an absolute right to proceed. The statute of limitations accrued as of April 2012, and all of their claims are barred regardless of any other issues. Thank you so much.
Mr. Marks, are these cases that you've been rattling off all cited in your brief?
Your Honor.
And to the extent they're not, you better file a supplemental.
I'm sorry, say that again, Your Honor.
I'm asking if all the cases that you've been mentioning on your argument, are they all cited in your brief?
Your Honor.
Are you telling us about cases that are not in your brief?
Yeah, correct. The only case that I've cited, Your Honor, that is not in our briefs are two: the Skeens case, which I just mentioned, and the Brault-Graham, because they respond to an argument made on reply by the lawyers. The Skeens case is 620.
Why don't you file a supplemental letter?
Thank you, Your Honor. I'll be pleased to do that. Thank you so much.
And by way of supplement, I would be interested in whether you all could provide the complete copy of the amendment to the assignment of judgment document. We have excerpts of it in the joint appendix, but not the complete document.
We'll do that, Your Honor. Thank you very much.
Also, in the record, you know, one thing about this case is funny. Your client is always referred to as the assignee of the claim. And when I first read this thing, I said, well, she's now the owner of it. That's what it means to be an assignee, property-wise.
She is the assignee.
But when I tried to read the assignment, to begin with, page 2 of the assignment, as somebody pointed out, isn't there. And that's the critical one where it talks about what she gets. And apparently the real owner of this claim is some kind of trust that was set up for the benefit of one of the granddaughters of the man who died. And maybe the JDC has some kind of residuary interest, but it's very, very confusing. And I think that the Friedman is correct in his brief and his statements here that it's really unclear who exactly has what rights in that property, but particularly because page 2 is missing.
So, Your Honor, we'll be pleased to provide the full agreement. We do not rely on that assignment for our arguments, just to be clear. It's an additional reason but we don't rely on that specifically for our arguments. But we'll be pleased to provide it to Your Honor. Thank you so much.
All right. Thank you, Mr. Marks. Mr. Friedman, you reserved a couple of minutes for rebuttal.
Yes, thank you, Your Honor. I think the fact that we don't know what that assignment states is actually a critical piece of information that really underscores the fact that all of the inferences that are to be drawn from our First Amendment complaint need to be construed in light most favorable to the plaintiff, not in light most favorable to the defendant. And I think that's where the lower court really turned 12b-6 on its head. But I want to return to an earlier question regarding the tortious interference claim. When Ms. NEIPRIS was aware of the existence of the contingency fee agreement and encouraged her cousins, our clients, to separate from the lawyers and not pay on that contingency fee agreement, she did so with the express emails that are referenced in our complaint, that to do so would leverage a better deal for the family. That is the definition of a tortious interference claim. If this court looks to Lannan Foundation versus,
not if she thinks that they have a right to do that. Not if she thinks that's perfectly consistent with the contract.
And I would submit, Your Honor, that it's not consistent with the contract.
I know.
Because at the time that she made those assertions, this court's pronouncements in Kashuva versus Hutter and other cases make it quite clear that if lawyers substantially perform, they are entitled to the benefit of that contingency fee agreement. And the arbitration finding wasn't that the lawyers just substantially performed, it was the lawyers did everything that they were required to do in fulfilling that contingency fee agreement. That was known.
Can I bring you back to a point? I don't mean to derail you, but Mr. Marks made a point. I just wonder what your response is. He points out that it's a little bit imprecise to say ACAB lacked jurisdiction over the dispute about whether or not those $400,000 could be recovered from the arbitration itself. Because ACAB it follows the agreement of the parties. So if the parties agree that it's part of the dispute, ACAB doesn't really have a reason to look behind that, and it wasn't disputed here. So all this business about whether or not ACAB, it might be that ACAB shouldn't have gotten into it. It might be that Ms. NEIPRIS could have said, hey, don't address whether or not that $400,000 is owed, but nobody did it. So it was proper. So it was in front of ACAB because it wasn't objected to, and it was part of the agreement of the parties that ACAB could decide it. What's your reaction to that?
My reaction to that is in our actual actions. We filed a tortious interference claim in Superior Court with full knowledge that we were not able to pursue anything other than the fees that we were claiming against our clients for failing to pay us on our contingency fee agreement. And this court's pronouncement in Ludwig is the best interpretation of what the ACAB rules, what they are, because this court said.
No, counsel, I'm granting you. Let's say the ACAB rules say they can't get into that. That doesn't mean that somebody can't waive their objection to it, though. All the time parties can say, I know this rule, my opponent filed their brief late. That's a rule, but I'll consent to it.
I don't think I don't think I could stipulate to this court that it has jurisdiction over a claim that has no jurisdiction over. The court is
it's not a jury, but counsel, I'm saying, what is your basis for saying it's a jurisdictional problem? I understand that the word jurisdiction appears in cases like Ludwig, but we have for decades, and the Supreme Court has made this point over and over again, that for a long time, courts are just really imprecise about what they referred to as jurisdiction. They often refer to rules as jurisdictional when they're not. And so my point is, yes, there might be rules that ACAB shouldn't have gotten into this, but there's no statutory constraint on them doing it. There's no statutory constraint on parties agreeing to let ACAB decide it. So it's not really jurisdictional. That's my point. And what's your reaction to that?
My point would be that it is in the form of a jurisdictional limitation. ACAB is supposed to be
just point me to where that limitation exists.
Well, the ACAB rules are designed to
You better point me to something other than the rules themselves, because we have made clear, as has the Supreme Court, that our own rules are not jurisdictional. It needs to be some external constraint, like a statute.
Well, the only external constraint, Honor, I can point you to is your court's own rulings that specify that ACAB is a court where limited proceedings can be pursued. And that is limited to the fees that one incurs in connection with a dispute with their client. The ACAB proceeding was set up precisely to create a forum where disputes between lawyers and clients would be settled in purportedly a streamlined process. If you would permit the parties to submit tortious interference claims and other things that are ancillary to it, you're defeating the whole purpose of making ACAB the streamlined procedure that the bar was hoping that it would be, and resolve disputes relatively quickly and inexpensively. The reason we filed the tortious interference claim in Superior Court and stated at the same time that we filed the ACAB proceeding was because we were limited in what we could pursue before ACAB itself. The Ludwig Court and the Rosenthal Court basically leave us with no opportunity to pursue Ms. NEIPRIS for the tortious interference that she committed against against us in the pursuit of trying to make sure we didn't get paid on the contingency fee and get the benefit of the bargain for doing the good works, holding Iran accountable, and actually getting money in the hands of the family of the victim that was murdered by the Iranians in Argentina. We did an excellent job, and then we had a cousin try and leverage our dismissal from the case as a means to limit our fee. That, under the Lannan definition of tortious interference, is in fact a tortious interference claim. In that case, a lawyer was aware that he had a grant that was supposed to be given to a foundation following the collection of his fee, and he refused to turn it over because he wanted to litigate the issue. And the court said that the mere knowledge of the existence of that agreement was enough to create a tortious interference claim. That's precisely what you have in this case. Ms. NEIPRIS tried to leverage the dismissal of the attorneys from the case to try and get a benefit for her cousins that was different than the contingency fee agreement that actually entitled us to receive what we ultimately did receive in the ACAB proceeding. We're entitled to pursue that tortious interference claim for her interference with our contract in a separate proceeding in the Superior Court. And the trial court's refusal to give the benefit and draw all reasonable inferences in favor of the plaintiffs that were detailed in the First Amendment complaint turns 12b-6 on its head. I appreciate the court's time, and happy to answer any additional questions, but I see my time is up.
Chief, you're on mute.
As many times as we do this, we always experience these mute moments. Thank you both for your arguments and your briefs today. We'll take the case under advisement, and you're free to exit the virtual courtroom at this time. Thank you.
Appreciate it.
This court is now adjourned.